A unanimous Supreme Court ruling was released this morning, and it fundamentally reshapes gun law in the United States. What makes this moment so historic is that all 9 justices agreed. That includes the 3 liberal justices who have consistently supported gun restrictions. When Sonia Sotomayor, Elena Kagan, and Ketanji Brown Jackson joined the conservative majority in striking down major gun control measures, it signaled that something significant had shifted. This 9-0 decision invalidates key gun restrictions across all 50 states and changes what governments are allowed to do when regulating firearms. This ruling impacts every gun owner and anyone considering gun ownership in America. The fact that the decision was unanimous, not 5-4 or 6-3, but 9-0 suggests that both state and federal gun control measures had reached a point where even the court's most liberal members could no longer support them. Here's what happened. On April 24, 2026, the Supreme Court issued its decision in United States v. Henderson, a consolidated case reviewing federal and state firearm regulations under the Second Amendment. The court ruled unanimously that strict scrutiny, the highest level of constitutional review, must apply to all Second Amendment restrictions. More importantly, the ruling struck down 5 major categories of gun regulations that were widely enforced across the country. First, permit-to-purchase systems that require government approval before buying firearms were invalidated. These laws existed in states like Illinois, Massachusetts, Connecticut, Maryland, New Jersey, Hawaii, and Rhode Island, requiring individuals to obtain a permit card before purchasing a handgun. The court determined these systems act as prior restraints on a constitutional right and cannot be justified. Second, waiting periods that extend beyond the time required to complete background checks were struck down. Many states had such laws. California with a 10-day wait, Florida with a 3-day wait, and Rhode Island with a 7-day wait. The court clarified that while background checks are permissible, any additional delay after completion is unconstitutional. Third, mandatory training requirements as a condition for owning or carrying firearms were ruled unconstitutional. States can still offer and encourage training, but they cannot require government-approved courses as a prerequisite for exercising Second Amendment rights. Fourth, good cause or proper purpose requirements for obtaining carry permits were eliminated. States like California, Hawaii, and Maryland, along with certain local jurisdictions, can no longer require applicants to demonstrate a special need for self-defense. Fifth, discretionary approval systems, where officials have subjective authority to deny permits, were also struck down. The court ruled that all permitting systems must follow objective shall-issue standards, removing any vague or subjective criteria that could be used to deny applicants. Chief Justice Roberts wrote the majority opinion, joined by all 8 other justices. The central reasoning emphasized that the Second Amendment protects a pre-existing right, and the government cannot condition its exercise on permission, approval, or unnecessary delay beyond verifying eligibility. The ruling reinforces that liberty is the default, and any restriction must meet the highest level of constitutional justification. This decision now forces states to rapidly adjust their laws and enforcement practices, as these previously common restrictions are no longer legally valid nationwide. Here's what you'll see in the next video, where the breakdown covers which states are losing the most gun control laws and what's happening right now as officials rush to comply. Make sure you're subscribed so you don't miss it. Now, moving on to how this affects all 50 states differently. Some states are losing dozens of restrictions, while others are barely impacted. The most affected states, those losing more than 10 restrictions, include California, New York, New Jersey, Maryland, Massachusetts, Hawaii, Illinois, Connecticut, Delaware, and Rhode Island. These states had permit-to-purchase systems, extended waiting periods, mandatory training rules, may issue carry laws, and discretionary denials, all of which are now unconstitutional. Moderately affected states, losing around 3 out of the 5 major restriction categories, include Washington, Oregon, Colorado, Minnesota, Michigan, Pennsylvania, North Carolina, and Florida. These states had some waiting periods, training requirements, or local discretionary systems that are now invalid. Minimally affected states, losing 0 to 2 restrictions, include the 25 constitutional carry states, along with shall-issue states that already had minimal requirements in place. Looking at specific changes, California's 10-day waiting period is now reduced to the time required for a background check, often just 1 to 2 hours. The firearm safety certificate is now optional, and counties that previously operated under may-issue rules must now follow shall-issue standards. In New York, the CCIA training requirements are no longer valid. Illinois' FOID card system has been struck down, along with a 72-hour waiting period. In New Jersey, the permit to purchase system has been invalidated. Now, here's what gun owners can legally do that was previously restricted. This ruling immediately expands gun rights in states that had tighter regulations. You can now purchase firearms without needing a permit card. In states that previously required permits, Illinois, Massachusetts, Connecticut, Maryland, New Jersey, Hawaii, and Rhode Island, you can now buy a handgun with just a background check, similar to purchasing a rifle. Walk into a store, pass the background check, and leave with your firearm. You can now carry concealed without having to prove a special need. In jurisdictions that previously required justification, you no longer need to demonstrate specific threats. The right to carry is now assumed. Apply, pass the background check, and receive your permit. You can also buy firearms without waiting for extended periods. Mandatory delays of 7, 10, or even 14 days are no longer allowed once a background check is completed. Another major change is that you can now carry without completing mandatory training courses. States that previously required long training sessions before issuing permits can no longer enforce those rules. Training is still encouraged, but it is no longer required. You can also apply for permits without worrying about subjective denials. Officials are no longer allowed to reject applications based on personal judgment. If you meet objective criteria such as age, background check clearance, and legal eligibility, the permit must be issued. A quick legal note: this is general educational information about a Supreme Court decision and its impact on gun laws. It is not legal advice. Laws are changing quickly, so always verify the current requirements in your area and consult a qualified firearms attorney before making any legal decisions. Also, a large percentage of viewers aren't subscribed yet. Stay updated with these constitutional developments by subscribing, especially with upcoming coverage on which states are complying with the ruling and which ones are pushing back. Number 4, how states are reacting to this ruling. Responses generally fall into 3 categories. First is immediate compliance. Constitutional carry states and most shall-issue states say they are already aligned with the ruling. States like Texas, Florida, Georgia, Arizona, and Tennessee see little to no change. Second is delayed compliance. States such as California, Washington, Oregon, and Colorado indicate they will need 30 to 90 days to update their systems, retrain staff, and revise application processes and forms. Third is resistance. States including New York, New Jersey, Illinois, Maryland, Massachusetts, and Hawaii are exploring alternative approaches. These may include replacing permit to purchase systems with mandatory but free training programs, rebranding waiting periods as cooling off measures, or converting may issue systems into shall issue frameworks layered with numerous strict objective requirements. Gun rights organizations are already preparing legal challenges against these workarounds, and because strict scrutiny now applies, new restrictions will be extremely difficult to justify. Number 5, why this unanimous decision is historically significant. A 9-0 ruling in a major constitutional case is exceptionally rare. No previous Second Amendment case had ever been unanimous. They were always divided decisions. The fact that the court's liberal justices joined the majority signals that certain gun control measures had become constitutionally indefensible. These same justices had previously dissented in major gun rights cases, yet even they did not support permit-to-purchase systems, extended waiting periods, or discretionary denials. The opinion establishes strict scrutiny as the controlling standard, the same level used for fundamental rights like free speech and religious liberty. Under this test, the government must prove that any restriction is narrowly tailored to serve a compelling interest using the least restrictive means. This standard places most gun control laws under serious constitutional pressure. The decision also rejects the idea of interest balancing, meaning courts cannot weigh policy preferences against constitutional rights. The Second Amendment is to be interpreted based on its original meaning at the time of ratification. As a result, policies such as assault weapon bans, magazine capacity limits, age restrictions beyond 18, and red flag laws lacking strong due process protections are likely to face significant legal challenges under this new framework. Number 6. What this means for future gun legislation. This ruling fundamentally changes how gun policy will be debated and enacted. For Congress, passing new federal gun control laws becomes far more difficult under strict scrutiny. Some narrowly tailored measures like universal background checks might still survive, but broader restrictions such as assault weapon bans or magazine limits are unlikely to hold up. For state lawmakers, the era of experimenting with wide-ranging gun regulations is effectively over. Any new law must be historically grounded and carefully designed from the outset. For courts, every gun-related case will now be evaluated under strict scrutiny, eliminating the previous tendency to defer to legislative judgment. For gun owners, this significantly improves the chances of successfully challenging existing restrictions. Number 7, the action plan to respond to this ruling and protect your expanded rights. First, understand what has changed in your specific state. If you are in California, New York, New Jersey, Illinois, Massachusetts, Maryland, Hawaii, Connecticut, Delaware, or Rhode Island, major restrictions have just been invalidated. Research what rules are no longer enforceable and which ones still apply. Second, take advantage of your newly recognized rights. If you have been delaying a firearm purchase due to permit requirements or waiting periods, now is the time to act before states attempt new regulatory approaches. Third, apply for carry permits under the new shall issue standard. If you are in a former may issue jurisdiction, submit your application early before additional objective requirements are introduced. Fourth, document any resistance from state authorities. If officials attempt to enforce laws that have been struck down, keep records, file complaints, and notify gun rights organizations. Violations of Supreme Court rulings can form the basis for federal civil rights lawsuits. Fifth, support legal advocacy groups that are preparing to challenge state-level workarounds. These organizations rely on funding and public support to continue litigation efforts. Sixth, stay informed and continue monitoring how states respond as this ruling reshapes the legal landscape. Stay informed about new legislation. States will move forward with compliance bills that may appear to follow the ruling but actually shift the burden in different ways. So keep track of what is being introduced and push back against any unconstitutional replacements. Action Step 7. Vote with gun rights in mind. This decision came about because presidents appointed justices who interpret and uphold the Constitution. Elections will decide whether these gains are preserved or rolled back in the future. Here's the bottom line. The Supreme Court has issued a unanimous 9-0 ruling that eliminates major gun restrictions across all 50 states and establishes strict scrutiny as the standard for all Second Amendment cases. Permit to purchase systems, extended waiting periods, mandatory training requirements, good cause standards, and discretionary approval processes are now unclear. The states with the strictest laws have just lost more than 10 major restrictions. Gun owners can now purchase firearms without permits, carry without needing to prove a special reason, and exercise their rights without requiring government approval. The fact that the ruling was 9-0 shows that even justices who typically support gun control concluded that these measures went too far. The constitutional issue has been decided, but that doesn't mean the fight is over. States are likely to respond with workarounds designed to technically comply while still placing pressure on those rights. Stay alert, support legal challenges, and make use of your rights before any new restrictions are introduced. This stands as one of the most significant gun rights rulings in U.S. history, even more impactful than earlier landmark cases. The application of strict scrutiny changes the entire legal landscape. Make sure you stay updated because the next discussion will cover which states are following the ruling and which are resisting it, along with how individuals can respond if state officials attempt to ignore the decision. Share this information widely as many people are still unaware that this ruling has been issued. Keep in mind this is general educational information about a Supreme Court decision and its impact. For specific legal matters, always consult a qualified attorney. Every state is now affected, and the balance of gun rights has shifted at the highest judicial level. Make use of those rights. Thanks for watching. In the next segment, we'll break down the first legal challenges to state-level workaround laws.